Welcome to Dorsey and Whitney's Labor and Employment 2021 Symposium. I'd like to introduce Ryan Mick, Labor and Employment Practice Group Head and Program Moderator. Ryan?
Thanks, Rima, and good morning, everyone. As Rima said, I am Ryan Mick, and I am privileged to be head of Dorsey's National L&E Practice Group, and it is my privilege to welcome all of you to our 2021 Employment Symposium. It has been 358 days since our last one of these, and I don't think any one of us would have expected to still be doing the next one of these in the same format, but here we are. That said, over the course of the last year, we've all looked for those opportunities to find silver linings in unfortunate situations, and for us today, that silver lining is that we have almost 1,000 people registered to participate in our symposium today. That's a number we simply could not accommodate if we were doing this in person. And so we're thrilled to have that level of interest from all of you, and we certainly enjoy and appreciate the opportunity to share with you any chance we get in whatever format circumstances allowed. So for all of you participating today, a big thank you from all of us. Before we begin, a few housekeeping issues. As you can see on your screen, materials and attendance forms are available for download from Dorsey's reminder email that was sent from the events@dorsey.com address. Please return completed attendance forms to attendance@dorsey.com. You know, these sessions always generate a lot of interest and a lot of questions, and while we're not in the same room to call on people and see raised hands, we do want to hear from you. So if you have questions as we go, please type those into the chat function, and we will do our best to address those if time permits. And I confess, given the amount of material we have to cover today, that's a big if. But to the extent that we can, I'll be watching those, and others will as well. So if we can answer your questions, we will do so. So please send us those over the course of the day. Otherwise, please follow up with the presenters or reach out to your trusted Dorsey advisor. We will be taking breaks between our panels today. Those may turn out to be a little bit different, perhaps shorter than we might have otherwise intended, given the amount of material that we have to cover and our intent to keep this on schedule so that we end on time. But of course, feel free to stretch your legs anytime you need to, and if you're not back on time, nobody here will ever know. In terms of our schedule, we've developed something that we hope will be very useful for you today. This derives in large part from questions that we've received from many of you over the past year and over the past months in particular. We will begin with a discussion of 2021 legislative and regulatory developments. As you'd expect, a lot having to do with COVID and recent laws that many of you are familiar with, and legislative proposals on that front as well. But as we hope we are seeing the end of the pandemic in sight, we're also seeing on a legislative basis a resurgence of interest in things not having anything to do with COVID. In Minnesota and elsewhere, for example, that includes things like paid family leave proposals and a variety of issues that you'll hear about regarding gender equity issues. And with a new administration in office at the federal level, anything is possible. So lots to talk about there. From there, we will go to a discussion of employment litigation risks in the post-COVID environment. Again, lots of questions about what sorts of claims we here at Dorsey are seeing, what courts are doing with the cases that they've had in front of them, sometimes for a long time over the pandemic, new cases as well, and the sorts of claims that we see coming down the pike at all of us. So that will also be a very interesting session. From there, we will go to what we have called affectionately the East Coast, West Coast squeeze, a perennial favorite for us at these symposia, because those of us here in Minnesota, we always like to hear that it is worse somewhere else than what we're dealing with here in Minnesota. But that said, if you have paid close attention to the legislative and regulatory development session, you know that it might not be far behind here in Minnesota. And then we will end with a discussion of HR and employment issues related to remote work. That is a huge issue, lots of questions, and that issue is not going away as we look forward to the end of the pandemic and what the new normal is. So we hope that's a very timely session in particular. With that, let's move into our first panel, That one's mine, and I am pleased to welcome my colleagues to the proverbial table with me here. In no particular order, Molly Sigel is Dorsey's Legislative Affairs Director, and she is also the Chief Lobbyist for the Minnesota Employment Law Council, which is a consortium of leading Minnesota employers that is active at the Minnesota Legislature year in and year out, addressing bills and proposals of significant interest to employers. So right now, Molly is neck deep in the Minnesota legislative process, and we will hear from her on that in a little while. Next, my partner, Tim Goodman, is in Dorsey's Benefits and Compensation Group. Like many of you, Tim is my go-to person here at the firm for many benefits issues, and we are very happy to have him joining us today to talk about what might be coming down the pike at all of you on the benefits front. And last, but certainly not least, my colleague and senior associate in the employment group here at Dorsey, Drew James. When the FFCRA was passed last year and the gauntlet was thrown down to employment practitioners to figure out what that law was and what it meant and how it would be applied in a very real-time basis, Drew picked up that gauntlet and quickly became a resident expert on that, and he has continued to do that as we've seen additional federal legislation come down over the past few months, including very recently with ARPA. And so we're very happy to have Drew joining us today to explain everything you need to know about federal legislation in 20 minutes. And I'm only saying that partially tongue-in-cheek. But with that, Drew, let's turn to you and let's start with where you would expect to start an employment symposium in 2021, and that is with the alphabet soup that is the federal legislation we've seen over the last year. Drew, to you.
Good morning, everyone. It's a pleasure to be here, and I'm very grateful to be able to start your morning with the exciting topic of federal paid leave statutes over the last year. And I like to start by giving the same refrain, frankly, that we gave about a year ago, which is there's a lot of uncertainty right now, and things can change very quickly. For example, as we'll get to with ARPA, we're still awaiting some Department of Labor guidance on what exactly the statute means. And so things can change weekly, daily, hourly. And so it's very important to make sure that you're up to date on the information as it relates to the statutes we're about to talk to. Dorsey does have a coronavirus website internally, and we do a pretty good job of putting out e-alerts and information that you need to know. And so make sure to go to Dorsey's Coronavirus Resource Center for the most updated information, because what we talk about today very well could be outdated next week. But let's get into the nitty gritty, which is there are 4 statutes we're going to talk about predominantly today. And hopefully everyone on this call is at least familiar to some extent with these 4 statutes. And there's always a risk of getting into some alphabet soup or acronym soup because the titles and names of these statutes are so long. And so just to make sure that we're all speaking the same language, the 4 statutes we're going to talk about today. The first is what was called the Families First Coronavirus Response Act. We call that frequently the FFCRA. That was the first law that was passed federally by Congress back in March of 2020, amazingly over a year ago. And that was a statute that first enacted what we call the Emergency Paid Sick Leave Act, the EPSLA. I'm going to do my best to just refer to that as paid sick leave. But you'll know when I refer to paid sick leave, that's generally what I'm referring to. And then the FFCRA also created a change to the FMLA that they call the EFMLEA, which is the Emergency Family and Medical Leave Expansion Act. The CARES Act is what followed, the Coronavirus Aid, Relief, and Economic Security Act, which was enacted at the end of March of 2020 on March 27. Then many months went by before we had a significant statute that impacted paid leave on a federal level. The next came in the form of the Consolidated Appropriations Act of 2021, which is the CAA, that was passed back in December 27 of last year. And then finally, the topic of the day, which is the American Rescue Plan Act, or ARPA, which was enacted just back in March, just over a month ago. So we can go to the next slide. I want to start by just talking generally about the FFCRA. And I'll start by saying, I am very hopeful that the vast majority of you on this call know whether or not the FFCRA applied to you. Because we're talking about a statute that was effective in April of 2020, over a year ago. If you don't know whether the FFCRA applies to you, my hope is that as soon as Dorsey's Symposium is over, you give someone on our L&E team a call, because we may have an important conversation to have with you to figure out where to go from there. And certainly for those of you on the call who are Dorsey clients, I'm sure you do already know whether or not this applies to you and exactly how to comply. Under the FFCRA, there are two types of paid leave obligations. The first is a paid sick leave obligation, and the second is the expansion to the FMLA, which we talked about earlier. And just the basic nuts and bolts of the FFCRA are that it applies only to smaller employers between 1 and 499 employees, that the employer is eligible for up to 100% reimbursement via payroll tax credits. So ultimately the onus is on the federal government to provide reimbursement. The paid leave is only available if the employee cannot work or telework due to a need for leave for a qualified reason. And the slide that you're looking at right now is our explanation of what the emergency paid sick leave obligations were in the FFCRA. It's a lot of information, and I'll tell you, I'm not going to walk through this word for word. We're putting up there just for completeness. If you download the materials, you can take a look at that and have it handy. But my hope is, if the FFCRA applies to you, if there was an obligation for you back in 2020 to provide paid sick leave obligations under the EPSLA or the EFMLEA, you've probably memorized the 6 qualifying reasons by now. And this slide also serves as a helpful reminder that there are both daily and aggregate limits, and they're really important, because if you exceed those limits, you could be denied the corresponding tax credit for the additional amounts. So make sure that you're keeping all of this in mind. And if we go to the next slide, the FFCRA creates a new category of FMLA leave for what's called public health emergency leave. And the big difference is that it's paid for the first 10 weeks, right? Typically, when we're talking about the FMLA, we're talking about unpaid leave. This is a paid leave obligation at 2/3 of the employee's salary level up to the aggregate limits. And you'll see on the slide that there's an eligibility requirement. The employee has to be employed for 30 calendar days, that there's a waiting period, that the first 2 weeks of the family leave are unpaid, and then the next 10 weeks would be paid. And we'll get back to that in just a minute, because that's no longer true. And all the EFMLEA does is create one new reason for an employee to claim FMLA leave, and that's to care for a son or daughter whose school or childcare is closed or becomes unavailable due to COVID-19. And as we'll get to in a bit, that also was changed pretty substantially by the ARPA. If we go to the next slide, I am not going to spend very long on the CAA, other than to say that the FFCRA didn't just expire on December 31, 2020. If there's anyone on this call who thought the FFCRA just went through the end of 2020 and that was that, unfortunately, that's not exactly true. So what the CAA and the FFCRA did is the tax credits were extended for the paid leave, but not the mandate. In other words, if you were previously subject to the FFCRA and obligated to provide paid leave, you no longer have to provide that leave. But if you do provide the leave, the tax credit is still available to you. And under the CAA, it was extended for wages paid between January 1 and March 31 of this year. And the Department of Labor does a relatively good job of releasing FAQs, sometimes not as timely as we would hope. But FAQ 104 is relatively important on this question, because it indicates that even if an employee was eligible for paid leave last year, the employer is no longer obligated to provide that leave after December 31, that the tax credit is only available for wages that were paid from January 1 through March 31. But if the employer decides to pay that leave voluntarily, they can still claim that tax credit. But no employee is entitled to FFCRA leave beyond December 31. And the key word there is entitled. If we go to the next slide, now we get to the major topic today, which is what's called the American Rescue Plan Act, or ARPA. This is a statute that was signed by President Biden on March 11. And unlike the CAA, this isn't just a mere extension of previously existing paid leave obligations and tax credits. There are actual substantive changes to the FFCRA's regulatory mechanisms. And so this is newish, right? We're talking March 11, it was effective as of April 1. And so hopefully those of you who are subject to ARPA already know, but if not, like with the FFCRA, give us a call if you'd like to discuss anything we're about to cover. We're very happy to talk you through. And also it's very important to keep your ear to the ground on legislative and regulatory guidance, because we're still waiting on that and it can have some pretty dramatic changes about what exactly employers are obligated to do or not obligated to do. So with no further ado, let's talk about the actual changes in the ARPA. The most important information to know on this slide for any company subject to FFCRA or the ARPA. The first is that, like with the CAA, the tax credits did not just simply expire on March 30. They have now been extended through September 30. So we are looking at an availability of tax credits to employers for both the FFCRA paid leave piece and the EFMLEA, the family leave piece, also paid leave through September 30. Also, like with the CAA, the mandate has not been extended. So everything we're about to talk about is strictly voluntary. But unlike the CAA, Congress made dramatic substantive changes to both the FFCRA and the EPSLA. For example, there are 3 new additional reasons why an employee may qualify for paid sick leave under the EPSLA, the paid sick leave portion of the FFCRA. The first is that the employee is seeking or awaiting the results of a diagnostic test for or a medical diagnosis of COVID-19, and such employee has been exposed to COVID-19, or the employee's employer has requested such test or diagnosis. So that's the first new reason. The second is that the employee is obtaining immunization related to COVID-19. And the third is that the employee is recovering from any injury, disability, illness, or condition related to such immunization after medical diagnosis. And that's a pretty significant change from the original FFCRA and the EPSLA. The 6 reasons we talked about before, it's now been broadened and expanded, and employers are going to have to keep that in mind if they so choose to offer paid sick leave between April 1 and September 30 cutoff. So if we go to the next slide, I put a reset button on this slide because that's functionally what Congress did. The way that they decided to allocate the new paid leave after April 1 is that it will only apply to wages paid on or after April 1, but there's a brand new bank of 10 days of paid sick leave for any employees that are at companies that are offering this paid sick leave. So employees are entitled to 2 weeks of paid sick leave, even if they exhausted all of their time that was allocated under the FFCRA in 2020 and the first quarter of 2021. And so that 2-week period has now been reset effective April 1. If we go to the next slide, I now want to talk about the EFMLEA a bit, because there are some important changes to know as far as the family leave portion of the FFCRA and how it changed under the ARPA. It's the same period of extension. It's going to apply to wages paid between April 1 and September 30, and that's what the tax credit is available for. One significant change is that there's now no longer a 2-week unpaid period. We talked about that in an earlier slide, and so now the 2-week unpaid period has been removed, and correspondingly the cap for aggregate paid leave has been increased from 10,000 to 12,000. So for employees, that's going to feel like 2 additional weeks of leave, because previously many employees had an incentive to run their emergency paid sick leave and the 2-week unpaid period under the EFMLEA concurrently to avoid that 2-week unpaid period. But now they can get a paid period of leave for the first 2 weeks under the EFMLEA, which allows them to save their emergency paid sick leave portion for other reasons. And so that is a really significant, sizable change if you're a company that is subject to the FFCRA and correspondingly the ARPA, and you're looking to claim a tax credit for wages paid under the EFMLEA portion. If we go to the next slide, This is another major change in the scheme for the EFMLEA, which is that before, all the EFMLEA did under the original FFCRA back in March of last year is create one new reason for leave. But now, the language that you see on the slide is right out of the bill. Employees can request EFMLEA leave for any of the qualifying reasons in the EPSLA, that's the list of 6 reasons we walked through earlier, and any of the new reasons that we just walked through in the ARPA. So it significantly increases the scope of what leave employees can claim under the EFMLEA. And very likely, this is going to significantly increase the utilization of the EFMLEA leave, particularly where an employee is seeking long-term leave for any of the qualifying reasons. So make sure that you keep that in mind if you choose to offer EFMLEA to your employees. If we go to the next slide, these are the questions that I have been hearing the most over the past month since the ARPA was enacted, which are companies saying, what if we offer only paid sick leave but not EFMLEA leave? Or can we only offer paid leave for employees who choose to obtain the vaccine but with the other reasons? Or what if we don't want to give the full 10 days under the statute? What if we only want to offer 1 day? And the answer is on the next slide, which is the Department of Labor has not definitively said yet what the answer is. As of this morning, we still have no guidance from the Department of Labor. And so it's important for you to keep checking Dorsey's coronavirus resource page. And I can assure you that if we get a definitive answer, there will be an e-alert on that subject. But as of today, here's what Dorsey recommends. Companies can choose any of 4 boxes to fall into. They can offer both emergency paid sick leave and EFMLEA. They can choose to offer neither. They can choose to offer emergency paid sick leave, but not the EFMLEA, or they can choose to offer the EFMLEA, but not the emergency paid sick leave. Because it's a voluntary program, companies can make any choice as far as those 4 boxes. So it's perfectly acceptable for a company to choose not to offer benefits under one or the other and simply not claim the corresponding tax credit. But if you want to claim the tax credit, our belief as of today is that your company needs to offer the benefits up to the limits defined by the ARPA. That means let's talk, for example, about the EPSLA, the emergency paid sick leave portion. You've got to offer the full 10 days. You can't offer fewer than 10 days. You don't want to offer 9 days. You don't want to offer 1 day because it creates risk that you may ultimately be ineligible for the tax credit. And you have to offer it for all reasons, not just one of the qualifying reasons, but all of the reasons that we've walked through today. And the risk is a company ultimately might be ineligible for that tax credit, which is a pretty significant stick. And so I would say if your company is intent on offering some but not all of the benefits, don't hesitate, give us a call and we'd be happy to help you try to maximize your chances to get that tax credit. But that's the situation as of today. If we go to the next slide, I'm going to go very, very quickly through the next couple of slides, which are just a high-level list of other things in the ARPA that you might want to keep your eye on because they may or may not apply to your company. The first is that there were expansions of various unemployment programs that were originally enacted in particular the CARES Act. And so you can see on the screen that there were expansions of the PEUC, there were expansions of the PUA, and by the way, the PEUC is for individuals who exhausted state law unemployment benefits. The PUA is for example, business owners, self-employed workers, independent contractors, individuals who previously wouldn't have been entitled to unemployment benefits. There was also an extension of the mixed earner unemployment compensation benefit through September 6th. And so this slide just lets you know that there have been some changes as far as unemployment. And so if you're dealing with a new request for unemployment related to COVID-19, just know that some of these programs are still in place, although for some of them at a reduced rate. The next slide is a pretty significant change, which is that there is now a non-discrimination requirement as far as the paid leave obligations under the ARPA. And so it's vitally important to ensure that you're offering paid leave benefits in a non-discriminatory manner without consideration of some of the protected statuses. And those that are listed on the screen aren't necessarily an exhaustive list, but they're ones that we think are likely to come up. And so you've got to make sure that you're not making distinctions based on those types of categories. And now more than ever, it's worth your time to consult legal counsel to discuss your paid leave benefits and assess whether there's any risk under this provision. And then again, very briefly, but there's been an extension of what's called short-time compensation programs, which are a reimbursement of unemployment benefits that are paid to encourage employers not to lay off employees. That's through September 6th. And then also an extension of the employee retention credits through December 31, 2021, including an expansion of the scope for those employers who are severely financially distressed. And if you'd like to, if you don't know whether or not that applies to you, don't hesitate, give us a call and we'd be happy to walk you through that. And so without further ado, to discuss some additional implications under ARPA in the area of COBRA, I'd like to introduce Tim Goodman.
Thanks so much, Drew. I'm going to be going through a number of slides here pretty quickly because there have been a lot of benefit developments, which is not very surprising, perhaps. I'm going to focus on the ones that I think are of most interest to you, which are going to be about COBRA and dependent care assistance. The sequence here I'm going to go through is I'm going to start with talking primarily about health and welfare plans, go very quickly through some retirement plan developments, and then talk about dependent care assistance. But let's start with COBRA, because I think this is the question most people have on their minds right now. One of the things the ARPA did was it created a subsidized COBRA program for the period of April through September of this year. And basically, employees who've lost medical coverage due to involuntary termination or a reduction in hours can have the opportunity to elect COBRA for this period. It's not just new people who are losing coverage due to termination, but this reaches back, and that's perhaps the most important thing to understand. The reach back is all the way back potentially to October 1 of 2019. I'll say that again, 2019, for people who lost coverage on after that date, in essence, or who were terminated and lost coverage on November 1, say, of 2019, their 18-month COBRA period runs through April of 2021. And so this is a big project for many employers who will have to go back and look at people who've been terminated to determine if they were involuntarily terminated or if they voluntarily left due to retirement or finding another job. And this is something that's going to have to be done in the next month. Next slide, please. In essence, the DOL did issue some guidance here just days ago, and this slide gives you some links to that, but if you were to Google it, you could also find it under DOL and COBRA and ARPA, I'm sure. Basically, the DOL's got two model notices, one for people who are going to be commencing coverage who are just losing coverage now, and one for those who lost coverage before April 1. And so there's two sample notices there. Employers do have to go ahead and work on those notices to complete things. One other notice that the DOL and the law basically requires is that you provide notice to people when their assistance period is ending. So there's an additional new COBRA notice in essence, and the DOL has a model COBRA notice for that. These are all things you'll want to discuss with your COBRA vendor and to work through, but this is probably one of the biggest to-dos. Employers are supposed to get these notices notifying people of their ability to elect COBRA and receive the subsidy by the end of May. Much like other things in the ARPA, the way that the COBRA is paid for is through credits with respect to payroll taxes. We're expecting there will be more guidance from the DOL and the IRS about this whole process. But at this point in time, we're still waiting on that guidance. The one thing we do have at this point are these model notices and some initial frequently asked questions from the DOL about the premium assistance that will be provided to people. Lots of questions have been starting to come into me about this, and I guess one of the biggest questions is, when is termination involuntary? Unless it's very clearly been a voluntary termination, i.e. someone who said they're leaving because they're retiring, someone who's leaving for another job, it most likely is good to be on the cautious side and probably treat that as an involuntary termination. One other question I've received is about people who've been terminated due to gross misconduct, because COBRA has an exception for that. And I think our word of caution about using that exception is it's running a risk that it might increase litigation if you deny COBRA due to gross misconduct, because that's not a well-defined exception under COBRA, despite COBRA being around a long time. And with the fact that people might then also miss out on paid health insurance, it might not be worth the risk to deny COBRA unless you have a really strong motive in terms of the gross misconduct exception. Why don't we go on to the next slide here, please? In addition to that, there's also some other burdensome guidance that has been issued by the DOL and IRS. This has actually been around a while, but it was clarified here at the end of February. So last year, the DOL and IRS said, look, due to the pandemic, we're tolling the time periods for people to make elections. So in essence, if somebody lost COBRA coverage during, say, March of 2020, what this tolling period rule said is, why don't you go ahead and wait and give people an extra year to elect COBRA coverage? So if their COBRA election period started on March 1 of last year and would have ended, say, on April 30th of last year, due to this tolling period, it's actually ending on, say, April 30th of this year. This applies not only with respect to COBRA elections, but COBRA premium payments. It also applies with respect to HIPAA special enrollment and ERISA claims appeal deadlines. And at the end of February, this EBSA notice noted at the bottom here basically said, instead of being one universal extension, it's individualized. So if someone was terminated, say in July, and their health coverage, their COBRA election period would have begun on August 1, that's the 12-month period starts on that August 1, and then they have the extra COBRA election period after that. If someone's child is born in November of 2020, the tolling period with respect to that HIPAA special enrollment election begins then. So this means that employers should really be looking at this. And in that notice, the DOL suggested fairly strongly that employers should make sure they've been notifying people of this right, and also providing notice about the end of this relief period so that there would be notice given to those employees. So this is another notice that employers should really be looking at. Next slide, please.
Say, Tim, this is Ryan.
Yeah.
Let me jump in, because as I've been monitoring the questions here, we've had a few that I think you may have just spoken to, but let's emphasize it because of the questions that we've had. If an employee previously did not elect COBRA, or if they had elected COBRA and then did not continue to pay their premiums, what should employers do about those? We understand the tolling now, but for the employees who either didn't elect or stopped paying, and now there's this new benefit, what should employers be doing as to those folks?
Okay, those are a little bit complicated, but let me go over it. If they elected and then they discontinued, I believe the guidance is that they should still get this new notice telling them about if they still have a period of time left in their 18 months as of April of 2021, they should still be getting this notice and given a new opportunity to elect COBRA and have that paid for through this premium subsidy. With respect to people who elected COBRA and made premium payments and then stopped making the premium payments, if they're still in their 18-month period, again, I think they'd get the notice with respect to this premium subsidy. I will note one of the more complicated things about both those questions is, well, what about the period of time, say, between when they stop paying their premiums and when the subsidy begins? Well, there's actually a tolling period even with respect to those COBRA premiums that people have extra time to pay those premiums. And so that's getting so individualized, I think they'd have to talk to counsel probably, but anybody who still has some time left in this 18-month period as of April, I think is probably entitled to one of these notices, notifying them that they have this right to get the premium subsidy and have COBRA coverage.
Thanks, Tim.
So, for sure. On the slide here, one other development, and I'm going to be going through this and the rest of the slides pretty quickly to try and keep us on track. One of the things the IRS has notified is that employers can make a decision if they want to allow people to change their elections under the health plan coverage this year. They did this last year. This is something that wasn't in any of the legislation, but the IRS has announced this is possible. Next slide, please. So real quickly, one of the questions we've been getting is about COVID-19 treatments and vaccinations. Basically, the legislation enacted last year requires group health plans to cover COVID testing and treatment and also vaccination in terms of their cost. We have, though, been getting questions about vaccination incentives and programs, and I guess you should consider talking to us or your counsel if you are thinking about doing that, because oftentimes employers will then say, well, show us some proof that you've gotten vaccinated or do this or that. And you might accidentally stumble into creating some issues with state privacy laws, GINA or ADA concerns, even an ERISA plan if you were to provide additional funds to people to get vaccinated. So those are some very brief considerations there if you're thinking of doing some incentives in terms of a vaccination program. Next slide, please. Student loans. So one thing that Congress had done last year is went ahead and said that employers could go ahead and help reimburse employees on a pre-tax basis for educational loans. This was basically under Section 127 of the code, which is normally tuition assistance for current programs, and it offsets against that tuition assistance. So if you're doing the student loan reimbursement, it reduces the amount of tuition assistance you can do. Congress has extended that for an additional 5 years, and some employers have been interested in that. Next slide, please. So I'm going to go through this even more quickly. There's been some relief for defined contribution, defined benefit plans. This slide here talks about the defined contribution plan relief. Basically similar stuff to what was enacted last year under the CARES Act. There's some relief with respect to distributions and loan relief. There's also some relief, though, if an employer, at the bottom, I'll just note this in particularly briefly, if an employer had high turnover last year or terminations because of the pandemic, there's a thing known as a partial plan termination, where if 20% or more of your workforce is turned over or terminated, you might have to vest that portion of your workforce. There's some relief under this law that might be available to you, and that's something you should look at in terms of things. Next slide, please. With respect to pension plans, defined benefit plans, there's also some relief in terms of funding and in terms of how benefits, in terms of just looking at the funding schedule and amortization for these plans. There's a lot of detail on this slide. I don't know how many people have these plans, so I'm going to just go on to the next slide, but there's some information if these plans are something you maintain. Dependent care assistance. Okay, this is where a lot more questions are coming in again. And with dependent care assistance relief, the first thing to note is about the ARPA. So the ARPA went ahead and increased the amount of dependent care assistance under Section 129 from $5,000 to $10,500 for people who use this assistance, and for people who work on, you know, that $5,000 limit has been in place for approximately 30 years. I think it hasn't ever been adjusted. So for this 1 year, Congress has gone ahead and increased that limit. Theoretically, this allows employers to amend their dependent care assistance programs to increase their dependent care FSA limit for this year. However, there are reasons that you may not want to do that, and you may want to just leave your dependent care assistance plan as is. First of all, one of the effects of adding this or increasing this limit to 10.5 is that even though Congress was allowing carryover and grace periods with respect to amounts from 2020 into 2021, many people would have had taxes on that amount carried over or brought forward through a grace period, because in essence, the employer, even though the employer is only reporting $5,000 or whatever that's being deducted each year, the way that the taxation on these dependent care benefits looks at is how much did you actually get reimbursed as well? And there's this form 2441 noted there. And so that's one of the risks, is that by just raising this limit, Congress has probably helped to avoid some taxation for people utilizing the carryover and grace period. The other risk to employers is there's a number of non-discrimination tests with respect to dependent care assistance. One of those tests, known as the 55%, is frequently failed by employers. And the result is that all dependent care assistance provided to highly compensated employees then becomes taxable. And a concern I have is if an employer has, if they haven't been running tests on this or haven't been checking, the penalty here is if an employee is highly compensated, let's say you increase the limit to 10.5, the person thinks that's all pre-tax, you run the test, you realize you failed, you then have to add in $10,500 to their taxable income, which will be a surprise to them and additional work for you. So one reason to consider that guidance. And then real briefly, next slide, please. There are some changes to flexible spending accounts and carry forwards there. This slide talks about that and ability to bring amounts forward into this year. And that's something that employers are already considering and doing. The next slide, please. And finally, and this is a nice transition to Molly here, is like there's been some Minnesota legislative action or inaction or potential action, I guess. One of them was a proposed legislation to require carryover of dependent care flexible spending amounts, and it was Molly who kindly caught this and brought this to my attention. At this point in time, Molly has kindly indicated that it does not like it is going to be passed this session, but this, because dependent cares aren't subject to ERISA, that would be something that employers would have had to have acted on. The other thing I'll just briefly note is all these tax law changes you see in part have implications under Minnesota state tax law. And we're hoping that Minnesota passes a Conformity Act to conform Minnesota state tax law to the federal tax law changes that have been occurring. With that, I will go ahead and turn it over to Molly.
Great. Thanks, Tim, and good morning, everybody. I'm happy to be here. Just want to reference the tax conformity slide. I realize not everybody on this webinar is from Minnesota, but just bear with us if you are not. There will be a significant amount of conversation about tax conformity, both on the PPP state taxation loan side, as well as the tax conformity that we did not do in 2018 and 2019. That will all probably come into play at the very end of session when they try to shut everything down, get the budget done, and move on into the next second year of the biennium. Just for everyone's reference, Minnesota is the only state in the country that has a divided legislature, and I think it's really important in terms of what we can and cannot get done as a state. It's almost like we're living in two different places. The House is controlled by the Democrats. They have a 6-vote majority. The Senate is controlled by Republicans. They have a 34-31 majority. And then we end up having 2 former DFL Iron Rangers that defected, and now we have an independent caucus as well. So you all know that the governor is also a Democrat. So I think that kind of sheds a light on everything that we do at the Capitol, and is really going to make it difficult to come to some agreement by the end of session. We've been legislating in a pandemic for a year, as Ryan mentioned earlier. I have not been to the Capitol since I think March 13th of 2020. The House is 100% remote. They are going in to vote. Some of them are going in to vote on the floor, although they are allowed to vote remotely. The Senate is working in kind of a hybrid model. It seems like most of the Senate Republicans are in having hearings, going on the floor to vote. Most of the Democrats are choosing to stay in their offices or work from home. As far as lobbyists and the public, we're pretty much shut out at the Capitol. Our ability to communicate is through, phone, texting, lots of Zooms. And so it's been a challenging time to be a lobbyist in this pandemic world. As far as the impact that the remote lobbying and the remote legislature has on the scope of work, it doesn't seem to me anyway that it's impacted that in any way, shape, or form. As of yesterday, we had over 5,000 bills introduced in the first year of the biennium. And we also still have a requirement to have a balanced budget by the constitutionally required adjournment date of May 17th. Next slide, please. As far as how all of this impacts employment legislation, I think it's pretty safe to say that the legislation that we saw pre-pandemic dealing with employer mandates are all still here. In addition, we've had some bills that have popped up where I believe have come from what some people believe is loopholes in the federal requirements, especially for employers under 500. So we have seen some legislation dealing with emergency sick leave and other issues dealing with that. It's safe to say that the leadership in the House and Senate are not aligned on what they want to do on employer mandates. There's a slide here that talks about the number of prescriptive benefit mandates and hiring practice bills that are currently under consideration in the House. Those include paid family medical leave, sick and safe time, prohibition on consideration of pay history, pregnancy accommodations and lactation break changes, emergency rehire and retention requirements. That's fairly related to, mostly related to COVID, and a retroactive leave payments for essential workers, which is also COVID driven. I know for those particular provisions are all included in the omnibus the omnibus workforce development bill, as well as in the judiciary bill. Those will pass the House floor probably sometime in the next 5 days. Across the street on the Senate side, we have a very slimmed down counterpart to that bill. It does not include anything, those first bullet points in the House version, except there is a version of the pregnancy accommodation and lactation changes, and there are some modifications to the 2019 wage theft law that I think most of you are probably complying with if you are in a Minnesota company. Next slide, please. So again, Ryan's going to go into the details of the Minnesota legislation, and I'll be here to provide some color commentary on what the process may look like as we move towards the end of session. But where we're at right now is the House is going to pass their omnibus bills, the Senate's going to pass their omnibus bills. Conference committees will be appointed to hammer out differences. In the event that those conferees cannot hammer out differences, I believe we'll end up with what we had in 2 years ago when they were trying to get through out of session, what we called as the tribunal, which is the Speaker of the House, the governor, and the majority leader of the Senate pretty much all got in a room and kind of hammered out what they were going to do on policy, appropriations, and taxes. In that process, I think some things fell, some of the details fell, to the floor. Some of those things were employment related, especially in wage theft. We hope that doesn't happen this year, because I think you kind of lose track and you lose the ability to be involved in the process in the event that will happen. But again, we have a constitutionally required adjournment on May 17th. So just cross your fingers and, stay tuned. So with that, I'm going to turn it over to Ryan. And if he has any questions, I will stay on to answer them.
So as Molly said, I'm going to spend a large part of our remaining time talking about some of the really significant legislative proposals that are percolating at the Capitol right now. Molly had a long list. We can't go through all of those in the detail each of them warrant. So I'm going to really talk about 4 that I think are most significant, either in the sense of some likelihood of passage, or if we can't say that there's a likelihood of passage, at least the level of interest in the intensity of the push, primarily on the House side, for these bills. Again, these are Minnesota bills, so if you're outside of the state, these are not directly related to what might be coming at you, although if you have operations in Minnesota, even though you're headquartered outside of the state, it could be relevant. But if you're outside of the state, my encouragement to you would be not to walk away right now, because what we're seeing in Minnesota really is consistent with trends at the national and other state levels. So if you're in another state, do pay attention, because if you don't have these bills, they may be coming at you in the near future. So the first bill to talk about is the proposed ban on the consideration of pay history. Now, this is only in the House Judiciary Bill. We do not have a companion that's live in the Senate, but this is one that has received considerable interest on the House side. And that's not surprising. About half of states already have some form of a ban on the consideration of pay history. And there's good reason for that. These bills are really intended, and there's a considerable research out there showing that they are actually successful at this, in breaking the cycle of gender inequity in pay by not tying women to past or current pay that might be inequitable or maybe even discriminatory. By not allowing the new employer in the context of an employment negotiation to know what the female employee has previously been paid, the idea is to break that cycle of inequity and allow female employees, female applicants to negotiate for pay on the merits of the job and themselves, not what they've been paid in the past. You can see the brief overview of this proposal on the screen, consistent with a number of other laws out there. The gist of the bill is that employers shall not inquire into, consider, or require disclosure of pay history. Applicants may voluntarily and without prompting disclose pay history on their own if they think it's useful to them or they want to include that as part of their negotiation. Of considerable interest to employers, and I'll come back to this in just a moment, the Minnesota bill would create a rebuttable presumption of discrimination if an employer considers pay history regardless of the circumstance. That is, even if the employee voluntarily disclosed their pay history, a claim could be brought on the basis of a rebuttable presumption of liability for that employer for considering pay history. That said, the bill does make clear that employers may engage in discussions about applicants' expectations or requests with respect to compensation and benefits, and that can be a point of negotiation between the parties in that context. We've seen a number of questions and concerns from employers about this. For example, some uncertainty about what it means for an employee to voluntarily and without prompting disclose pay history, and that's significant because of the potential liability for employers. Employers are asking, if I don't ask for pay history, what does it mean that I might prompt an employee to disclose that in a way that could get me in trouble? We don't have a lot of clarity around that. So it is a concern out there. That said, really the key issue of concern for employers right now is this rebuttable presumption. That is not a provision that is present in other bills, in other state laws that are out there. There's no precedent for it under Minnesota law or federal law that is out there. For example, the Minnesota Human Rights Act doesn't have a rebuttable presumption. Title VII doesn't. None of the existing statutes in Minnesota and more broadly have this rebuttable presumption. And it really is a concern because it subjects even good employers, all of you who are trying to do the right thing, who aren't asking these questions, aren't soliciting pay history, may have simply received it inadvertently or by the result of an employee's voluntary disclosure. If, as a result, there is a dispute over that offer of pay or that pay that is ultimately provided to the employee, and they think the female employee thinks that pay is discriminatory or inequitable, a claim can be brought, and for the first time under non-discrimination law, the burden is on you as the employer to prove the negative, to prove that you did not discriminate against the employee in that context. So a lot of concern around that provision. And frankly, the view on the employer side is that it's not necessary. Lots of good can happen. Lots of basically all the reasons for passing this legislation that have been asserted by the proponents, and rightly so, can be achieved without this rebuttable presumption. And so a lot of concern about that in this bill. Next slide. Next, we're going to move to pregnancy accommodations and lactation breaks. A number of things in play on this slide. In the House bill, you have provisions that would expand the pregnancy and parenting leave entitlements currently under Minnesota Statute 181-941 to small employers and eliminate the 12-month employment requirement for eligibility. So if you're a large employer, you've been dealing with these accommodation leave requirements already. But if you're a smaller employer, even if you have one employee, under the House version, you could now be subject to these requirements. All employers, including the large ones, would have to deal with the elimination of the 12-month employment requirement in favor of a 90-day requirement only. Likewise, the House version would expand current pregnancy accommodations to small employers as well. Again, that's something that larger employers have been dealing with already. And both the House and the Senate version of this bill do have a provision that requires paid lactation breaks. Where it differs is what you see in the sub-bullet points at the bottom there. It's unclear right now whether the bill under both versions would require employers to give employees full discretion as to when they take and how many paid breaks that are taken by the employees, or whether employers would have some leeway to say, you have a regularly scheduled paid break, that can be your paid lactation break in whole or in part. Likewise, under the House version, the House takes out any exception for undue disruption to the employer's business in connection with these breaks as an exception. So that's also an area of concern for employers. Next slide. Paid family medical leave, and we could talk a long time about this because it's a very hefty, very complex bill, but the gist of it is that it would bring to Minnesota a California or Washington-style paid leave insurance program. It would apply to all employers across the board, large and small. If you have one employee, you could be swept into this. Premiums would be withheld by employers, again, very similar to what we see in California and Washington. But in order to split the cost of this, employers could decide to withhold 50% of the premiums from the employees. So at the end of the day, the cost of this could be borne 50-50 by employers and employees to the extent that the employers choose to do so. Now let's get into some of the more concerning things. Coverage would extend to most workers. Let's keep the slide back here for just a moment. Coverage would extend to most workers, and here's the kicker, including most traditional independent contractors. The statute has a very lengthy 9-factor independent contractor classification test that isn't quite as onerous as the ABC test for those of you who have been following that, but is very restrictive. By way of example, only if you have independent contractors who are paid on an hourly or weekly basis, they would be considered employees for purposes of this paid insurance program. And so you'd have to deal with withholdings and providing that benefit to them. There would also be new notice, record keeping, and reporting obligations that I can't even begin to describe, but would be pretty onerous for a lot of employers. Next slide, please. One of the areas that has really concerned employers on this one is that contrary to current law under federal and state law that provides for 12 weeks of leave, this proposal would require employers to provide 12 weeks plus 12 weeks. So in other words, employees would be entitled to take 12 weeks of paid time for their own serious health condition or pregnancy, plus an additional 12 weeks of paid time for safety leave or family care issues. And there are circumstances where it might even be greater than that if we're dealing with military care issues or, and I can't get into this, the possibility of different qualifying circumstances under federal and state law, which could create the circumstance where employees might be entitled to even more than 24 weeks, which already is 40% of the working year. In addition to the 12 plus 12 problem for employers, this isn't only an insurance bill. Let's be clear about that. This bill would expand actual substantive leave rights for Minnesota employees. That is, even if they didn't apply for insurance, if they have a qualifying reason for leave, this bill would say that they now have an absolute right to that leave, including the right to bring retaliation, discrimination, the whole panoply of potential claims against employers if they don't think that they've received the protected leave to which they've been entitled. That includes safety leave. Employers in Minneapolis and St. Paul have been dealing with that for some time, but now that would be a state level of requirement, as well as an expanded definition of family members to include grandparents and members of the employee's household, basically a roommate in certain circumstances, as well as broader definitions of serious health conditions than we currently see in the FMLA. Next slide. The last one I'll talk about very briefly is the proposal, and this is only on the House side, for a statewide sick and safe time entitlement, which would basically apply what Minneapolis and St. Paul and Duluth employers are already dealing with on a statewide basis. Also of a concern for employers is that there is no state preemption in this bill. So to the extent that one of the cities or another jurisdiction would expand rights applicable to employees who want to take sick or safe leave in their cities, the state bill does not preempt that. So there's a distinct possibility of employers having to deal with a state mandate and a local mandate going forward if this were to pass. So next slide. In the time that we have left, let me talk just a little bit about trends and potential developments that may be coming down at us on a broader basis. At the federal level, as I said in my introductory comments, we have a new administration. Everybody knows it, and they could not be more diametrically opposed on a number of employment-related issues. So we could see, based on what we saw from candidate Biden and what he said would be his legislative priorities for his administration, we could see an increase in the salary basis threshold for exempt employees. That was something that the Obama administration was pressing, and that didn't come to pass in as significant a way as the Obama administration attempted, but we could see that come back here. Independent contractor misclassification. Could we see a return to Obama-era guidance that really moved from the traditional control test for independent contractor classification to more of an economic dependence analysis? Or do we even possibly see a federal ABC test, which would, to call a spade, potentially really render the independent contractor classification null on a federal basis, given the severity of that test? Likewise, we could see a return to an emphasis on expanded joint employer status. Again, under the Obama administration, the deliberate purpose was to expand joint employer liability. The Obama administration wanted as many entities on the hook for employee entitlements as they could muster, and so they expanded the joint employer test, again, focusing more on economic dependence than what had traditionally been considered the sort of horizontal joint employment status that was out there for years before. Pay equity, another legislative priority for President Biden, to eliminate the factor other than test defense for employers and really require employers to provide reference to a bona fide objective factor to justify perceived inequities in pay, as well as restrictions on non-competes and restrictions on mandatory arbitration and class waivers. I think those last two in particular are unlikely to pass Congress, but they are out there as things to watch. The next slide. We could talk about this one for a long time as well. So this is really just issue spotting for all of you. The Department of Justice, for the first time, although we started to see this percolate back in 2016, has now in several cases started to pursue criminal enforcement against companies, against employers for alleged wage fixing and no poaching agreements. So in other words, if you as a company, if you as an employer have some sort of explicit or implied agreement with another company, usually a competitor, that results in wage fixing, in other words, holds down wages for employees across the industry or across that relationship, or you have a no poaching agreement with a competitor or another company, in other words, you're not going to try to take their employees and they're not going to take yours. The DOJ is now looking at criminal enforcement against those sorts of scenarios in a way that we've never seen before. So if that's you, pay attention and certainly give us a call, because that is a concerning development. Next slide, please. Some other national trends in terms of state legislation. Again, things that we've seen and talked about before, even in this presentation. Paid family leave and paid sick and safe leave. We've seen new legislation in California, Colorado, Connecticut, Maine, Massachusetts, and New York, and we're seeing it percolating in Minnesota and elsewhere. But in those states that you see on the screen, you actually have new statutes that you now have to grapple with as employers. A very concerning one for employers in Colorado is a new restriction on exempt status in 2021. As many of you know, under the FLSA, the administrative exemption is the easiest to challenge, but it's also the broadest. You see lots of employers classifying employees as exempt under the administrative exemption. That is, if they are exercising significant discretion and independent judgment over significant matters in a wide variety of functional areas, they could be exempt under the FLSA. Not so any longer in Colorado, a very restrictive definition of that administrative exemption. I won't go into it more, but if you have employees with that exemption in Colorado, pay attention to that, because that's a real problem for you right now. Pay equity, we have a new bill, a new law in Colorado, much along the principles that we've already discussed. COVID paid leave, again, in the interest of time, I can't go into that, but we have new 80-hour paid sick leave requirements similar to FFCRA principles in Colorado and California, with notice requirements there, as well as several cities in California that have their own COVID paid leave laws. Next slide. Other trends, what are we likely to see coming down at the state level? Non-compete restrictions is definitely one of them, and I mentioned that in the context of federal law. Probably not going to see much traction at the federal level. We may see more traction in certain states to restrict the use of non-competes. The low-hanging fruit there is the restriction of non-competes for low-wage workers. Kind of the argument being made is that you should never see an employee of McDonald's or Target or Walmart who's just on the floor or working the register be subject to a non-compete. So that's kind of the low-hanging fruit. We'll certainly see that. But we're seeing a wide variety of restrictions in other states under different circumstances, whether those are industry-based, whether those are earning-based, whether those are based on the time of employment or other things. I think we're going to see additional restrictions on non-competes at the state level. Likewise, independent contractor misclassification, we may see tightening of those rules on a state level. Predictive scheduling, so making us all shake in the way that we shook back in 2014 in Minnesota. Chicago has passed a predictive scheduling ordinance. We don't have anything, don't panic yet. We don't have anything concrete on the books in Minnesota or elsewhere, but it is still out there. We could still see something like that, as well as marijuana legalization. We're seeing a lot of that either for medical marijuana or simply recreational use. And that, of course, would have implications in the workplace depending on the provisions of those laws and whether employees are able to use marijuana for various purposes and what that means when they might have it in their system or, heaven forbid, come to work under the influence. So we are right at the end of our session. We threw a lot of information at you. We've seen a number of questions coming through. How can I get these slides? We want to take another look at what has been said. That was, again, part of what was sent out to you. If you do need it, let us know and we can resend the link to you. Again, a lot of information, so we thank you for hanging in there with us. At this point, let me extend my thanks to Molly and Tim and Drew. Great stuff, all very important things for our audience to know. We know that we've had a lot of interest and we will continue to do so. At this point, we're going to take a 5-minute break. We will come back at just about 9:40, so stretch your legs, go get that second cup of coffee, and we will see you again in just a few minutes. Thanks.